Alright, so for my summary, I did the case study of Berman versus University of Notre Dame, and these are my findings. So, on the day of October 27th, 1979, Christina Bierman and her husband were attending a football game at the University of Notre Dame. Assuming to beat the rush of traffic after the game, the Biermans left the game early and headed to their car in the parking lot. On the way to the vehicle, there were two other individuals in the parking lot, and they were having a fight or a brawl, and they assumed to be intoxicated. The fight was supposedly ended when they separated and walked away. The man who walked away then closely proceeded to walk by the Biermans, and while walking by the Biermans after he passed them, fell backwards onto Christina Bierman. This resulted in a broken leg for Mrs. Bierman. Looking around the parking lot, the Biermans discovered there were no security guards, ushers, or anybody else in the area when it happened. So this raises the question, does the University of Notre Dame have a duty to protect Mrs. Bierman from the injury that resulted from the drunk man in the parking lot on the university's campus? So there's two sides of the argument. The first side is that Bierman argues that since she was a business invitee of the University of Notre Dame to the game, she should be owed a duty by the university to protect her from any third-party patrons on the premises. So the university argues that there was no notice or knowledge of a third-party danger to the patron as she was leaving the game, and so that they are not liable for the acts of a third person. So, reading further, some general rules that apply to this, because the possessor of the land, which would be the university, holds this business area open to the public. So, since they hold it open to the public, they are liable to the members of the public while on the land. But there is a duty to provide police presence on the land, but it's only needed if there's reason to suspect that acts of a third party are going to occur that are dangerous to the patrons that are on the premises. Alright, so that being said, kind of my opinion and what's said in the book is knowing that this is a football game, knowing that there's tailgaters, rival opponents, alcohol, and basically sports in general happening in your parking lot. That honestly means that the university should provide a police presence during all of these events, which was not stated in the book, but I feel like during the pre-game events, there was a police presence. It's speculation, of course. But then, after the game, they said there was no police presence in the parking lot. Well, you have to think that they left early, so during the game, it is your own personal responsibility if your car is broken into, if something is stolen, that is on you. That's not on the campus. That's not on the university. So, saying there was a lack of security in the parking lot when that happened is that maybe they weren't in that area, or also maybe they weren't needed at that time and were going to come out right when the game ended, when everybody left the stadium and proceeded to their cars. So, the fact that there were those extra fans in the parking lot while the Biermans were walking to their car early, leaving the game early, is kind of hearsay, because yes, the university probably should provide protection in the parking lot in case there was an incident from a third party that would put her in harm's risk. But there's also no need to say that the university knew she was going to be in harm's risk or harm's way when leaving the game early. So, does Mrs. Bierman deserve to get a settlement from the university because of her broken leg, or does she not? So, the end of this says that, let's see. The end of this says that this case is going to go to trial court, and the proceedings of this case are going to be consistent with the opinion that the question is whether the protective measures employed by Notre Dame were inadequate. And they're going to use all the points I just proved and pointed out to decide whether or not she deserves a settlement from the University of Notre Dame. I, personally, in my opinion, think that if you go to a game, you know the risks. You know that there's going to be drunk college kids, there's going to be drunk civilians, there's going to be footballs flying in the air, hot dogs grilling cars you could possibly get hit by. Like, there's all these risks by going to a football game. Just because you were invited by the university doesn't make you special or different from any other person that would attend the football game. So if it would have been a regular college student that got her leg broken, that wasn't invited by the campus or university, would they have sued for the same reasons? And I don't think they would have, and I think she's using the fact that she was invited as a business whatever to the game. I think she's using that to try to get a settlement from the campus when drunk people happen. You should have been more aware of your surroundings. You should have walked farther away from the incident that was occurring to protect yourself. So those are my views on it. Of course, it says there was absolutely no decision yet in the case. So if I was a judge, that is something I would consider. Did you think of protecting yourself? Because you can't always rely on somebody else to protect yourself. So hopefully these are answers that work really well and you like, and I would love to know your feedback on my opinions.